Provo, Utah. Over 5 days in July, prosecutors laid out their case against the man accused of killing Charlie Kirk. It started on a rooftop.
Officer, upon seeing this disturbance in the gravel, you've described what it looked like to you.
Yes.
Someone lying down in a prone position, correct?
Yes.
What did you do next?
So when I got to the top of the Losi building during that day, I noticed the screwdriver, kept going to the edge, found that prone position. At that moment, I realized, because it was direct line of sight, plus the disturbance in the gravel, where I could see somebody laid down in a prone position or a sniper position, and asked dispatch to get on the then I realized that we probably didn't have our shooter in custody.
This wasn't a trial. A preliminary hearing asks one thing: is there probable cause to send the case forward? Not proof beyond a reasonable doubt, just enough to proceed. The case begins with cameras. Prosecutors stitched campus surveillance into one timeline, ending on the Losi Center roof. The state says this figure is Tyler Robinson. The defense spent 5 days testing what any single camera actually proves. The clip they return to most is the roof itself.
But the video on the roof was not distinguishable, fair?
That video as a standalone?
Yes.
It was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you at some
Note the qualifier, as a standalone. The state says it was never meant to identify anyone alone, but the defense's point lands. The most dramatic image in the case can't tell you who is in it. Then the same investigator was asked about the moment after the roof.
submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay.
Inference is an observation, and the witness drew that line himself. It cuts both ways. No visible gun isn't proof there was none, but this link rests on inference, not sight. So the state turns to physical evidence. 2 items, a towel around the recovered rifle and a screwdriver from the roof. The FBI examiner said Robinson was included as a possible contributor to DNA on both, at her labs reporting sealing. This, prosecutors argue, is the link the cameras can't supply. The defense didn't dispute the testing. It asked what a result like that is allowed to mean.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when
A second limit is written into the same policy.
have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
Can you
sorry.
take that down?
Can you clarify your question?
Yeah. When it refers to don't state that there
Both are standard science, not findings against this case. No error has been shown here, but they mark DNA's edge. It can tie a person to an object, not say how the DNA got there or when. His profile was on those items. The step from the towel to the act is one the DNA doesn't take. The state's answer, It never leaned on any single link. On day 4, prosecutors read into the record messages they attribute to Robinson from a state exhibit.
I grabbed my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
If we could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you.
If authenticated and admitted, that exhibit is the most direct evidence in the case, and none of that is decided. The hearing showed only that the messages were read from an exhibit, not authorship, not completeness, not truth. The defense fought the framing, and the court ordered redactions. The messages weren't the only words. Prosecutors also played video testimony from Robinson's former roommate, Lance Twiggs, about the hours after the shooting.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy.
By the state's account, that is Robinson admitting to it. But it is one person's recollection, not a recording of the act, and the same witness said Robinson spoke of turning himself in. The defense objected to it being cast as a confession. The court ordered parts redacted, and its weight is undecided. 2 readings of one record. The prosecution's is convergence, cameras, forensics, and words all pointing one way. The defense's is accumulation, a route that names no one, an object identified by inference, DNA that can't say how it arrived. At this stage, the law doesn't ask the judge to choose.
But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard.
Under probable cause, the evidence is read in the light most favorable to the state, and credibility is left to a jury. A challenge can be real and still not stop a case here. Which leaves the decision. At the end of day 5, the judge did not rule.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties.
Briefs run through August. Argument is set for September 1st. Until then, nothing is decided, not whether the case proceeds and certainly not guilt. Tyler Robinson is presumed innocent. What the hearing settled is narrower. The state's own witnesses said the roof footage can't identify anyone, and the DNA can't establish how or when it got there. Those questions are still open.